We are just going to get started because we have a pretty tight timeline today. Just a reminder, this is a public meeting, so it's being recorded. Both the video and transcript will be available afterwards upon request, if you'd like it. Also, very much like last time, because it's a public meeting, we ask that you not utilize the chat. And just unmute yourself or raise your hand if you would like to speak. So let's get started. This is the schedule that we have for today. We do not have a lot of time, and there are some pretty big decision-making points that we want to get through within this time. And so we have designed this presentation in a very focused way to address these critical issues. So please, for as much as you can, please stay on track so that we can get through each decision-making point in a timely manner, okay? Understand that there has to be discussion and all of that, but CJC staff will kind of work to corral you all if we get off topic or get off base a little bit too much. So very focused. We just don't have a lot of time with quorum. So we did have one protest based on the decisions that you all made last time we met, conflict artistry. And before we get into what the applicant is protesting, I'm actually going to turn it over to Bridget to go through the protest process real quickly.
Sure, thanks, Rachel. Hi, everyone. Good morning. I'm Bridget. I still work here. So one of the things that this program is a little different with is that unlike any of our other programs, the advisory committee or the review committee has exclusive authority to approve awards. And I know we described that in our last meeting. And one thing that, we learned things in implementation. We were under the impression that the commission could review these contingencies that you set forth. And upon reflection and some thinking, that didn't seem right. So the reason you're back here today for the the 3 applications where you had questions about is to review whether the applicants submitted answers that answered your questions so that you can make a full final decision on whether that application should move forward. Sending that contingency stuff to the commission wouldn't give you full authority to actually accept an application in full. That's why we're here today on that. The protest process is the process by which an applicant who was not funded can essentially ask you to reconsider. In order to do that, they have to come up with two particular things. They have to have a statement as to why they believe you were in error, either in the process you took to get to a decision or the decision itself. And they also have to identify what piece of the program wasn't applied correctly, a law, a rule, or language of the RFP. So conflict artistry did that, and that's where we'll go from here. But I just wanted to set up sort of why we're here on those 2 different points today. And if you have any questions, please feel free.
Any questions before we move into,
It's not a question. I have my thoughts.
Okay.
But if other people have a question, I'm happy to wait for that.
No, I don't see anybody else, so go ahead.
Okay. So there's a lot about this application that I really like. However, there are many unanswered concerns that are deal breakers for me. I did not feel like the appeal letter addressed the concerns that were mentioned. Specifically, there wasn't, for me, I didn't feel there was an identification of the types of crimes that they would be performing RJ services for, and that is concerning to me because the communities that they suggest that they will be serving can be insular, protective, resistant, or afraid of outside interference of law enforcement. And so a lot of times that can promote hiding of crime, or not addressing crime for the sake of the greater community. And I'll tell you, I come at this with a little bit of bias because I do come from a community like this that protects the community over the people. And so I didn't feel like this application addressed what types of crime they were going to be addressing. There was also, because they don't have relationship with systems partners, there was not an understanding of how, even if they did provide services on a crime, how that they were going to prevent those crimes from being charged and prosecuted. So, and they hadn't developed any additional memorandum understanding. And so those things for me, things like having an understanding of what their mandatory reporting is going to look like and what best practices are going to look like. And maybe some of that has to do with the limited wording that was allowed to be submitted. However, I didn't feel like it got addressed in the appeal as well. And I'm going to conclude by saying that I would not be able to approve this as it is. However, they were an applicant, and I know that we do have money, don't know what we're going to do with it, on and on. I would suggest, because I do like the concept of this, I would suggest that this be reapplied for not as a program, but as a program development, a grant for program development, so that they can address and look at all of these things and get all of these things in place before they start providing services. That would be my suggestion.
Okay, thank you. I actually have a slide to go through real fast on, that's okay. I didn't want to interrupt you. It's okay. So basically the basis for denial of approval for conflict artistry, was that the application did not sufficiently demonstrate an ability to work collaboratively with system partners. It lacked evidence of outreach or any information explaining how cases would result in system diversion. And there was not enough information describing how referrals would operate within the program. So their letter, their articulation of committee error, stated that the RFGP does not require partnership with criminal legal systems. The application expressed a willingness to collaborate with system actors on certain terms, and the program attempts to engage with harm directly in the community before contact with law enforcement. And referrals would be sourced directly from community members and community organizations. And then I'm going to turn it over to Bridget to address the applicable program rules.
Thanks, Rachel. Yeah, I mean, essentially, I think folks might be familiar with this, but the bill itself requires that applicants demonstrate in the application coordination with CBOs and the ability to work collaboratively with system partners. That's restated in rule, which we didn't repeat on the slide. And then we have a definition, or not a definition, but sort of an explanation in rule about an ability to work collaboratively with system partners may be shown by demonstrating a willingness to communicate with or involve system partners in the program, does not necessarily require involvement. So I think for you all to be thinking about, is expression of willingness an adequate demonstration of the ability to work collaboratively? And I think, Charlie, to what you were just saying, that's kind of, that's where you would kick off your discussion, as how well do you feel like the expression of willingness met those program parameters? Another thing to think about is, depending on what you decide today, well, here, I want the community or the committee to discuss first, and then we'll get to options later. I don't want to get the train off the track. So
I actually think it would be helpful to know what the possible outcomes of this contested process is. So is it, is it continued denial? Is it approval? Is it approval with contingencies? If you could just
Sure.
yeah.
Thanks, Elaine. I was going to suggest that, but then I didn't want to, interrupt anyone from discussing. So if the group today decides, no, this does not meet our definition of, or it does not sufficiently demonstrate coordination or ability to work collaboratively with, which is the basis for the first denial of approval. This application is done for this cycle. That's it. There are other administrative remedies outside of the agency, but that's not something we have control over. If you wanted to reconsider and take a look at, I know that the applicant submitted new communications with system partners that were not in the original application. You could say, all right, we're going to discuss this and see if that new information makes us think differently. I would suggest that maybe if that's the thing you need to decide today is, are we going to deny or do we want to reconsider? I don't think we have time for the reconsideration discussion to take place today. So does that answer your question, Elaine? Are you going to continue to deny or would you like to reconsider?
Okay. So one of the things that helps with is the details of it sounds like we don't really need to talk about the details that we would reconsider. We just need to talk about whether or not it meets enough of a standing to reconsider. So we don't have to hash out all those details right now. Okay, that's also helpful. Thank you. Well, I will just go ahead and add my thoughts while we're here. One of the things I did see that there was an outreach that happened to additional system partners. What I didn't see as clearly is, and maybe somebody else did see as clearly, what the outcome of those outreach efforts were. And also, if there is this pre-contact with system effort that's happening, which is the most brilliant aspect of this proposal. And we all said this. We were very excited about this proposal for exactly the merit that was stated in the protest letter, that this is an opportunity to really bypass system engagement. We do need to see, for the purposes of this particular funding, how it will result and how the tracking will be done to show that it results in diversion from from prosecution and from incarceration. And so that's the part that still feels hard to find. And then also capacity and willingness is, I'm glad that you showed these definitions, because an ability to work collaboratively, demonstrating a willingness is very clearly done here at that sort of level. Willingness is there. And experience of the individuals that will be working in the program sort of alludes to that really clearly as well. It's not as clear in the application that the willingness translates to agreements. And that doesn't seem to be the requirement here. So I will just leave it at that.
Aaron?
Yeah, I'll go next. I remember when I initially reviewed this application thinking it was a fantastic application for a different grant. And I think I'm still there. This conflict artistry has shown a real commitment to wanting to get upstream of interacting with the criminal legal system by going into the community, finding conflict not otherwise specified, and taking referrals from all quarters. I think that has incredible social value. It's not what the grant asks for. And we made the decision to elevate person felonies and person misdemeanors and crimes that carry a presumptive sentence of prison. And you can't get at those without close engagement with systems partners. And there's just nothing here that suggests that they have a pipeline to even get to those restorative justice, because, you know, if there's a practical way of when there's a short-circuiting the entire system's response, even without talking to them and going straight into restorative process, I'm not aware of what it is. So even though I like this application it's a social positive and a good idea sort of way, I just don't feel like it, even now, it meets our criterion.
I'm going to get to my recommendation first. My recommendation is to ask them to kind of come back with further evidence. I'm trying to find people's faces and names and stuff, but kind of where some of the previous comments got to is I think the protest identifies some further movement in answering some of our questions. I'd like a little bit more hard evidence, like additional signed MOUs from community partners, a bit more of a formal kind of, you know, commitment to engage with some system partners who would say, yes, we will participate, or, you know, I don't think, I wouldn't want to fully deny it right now. I think there's some merit here, and I'll, you know, I think what it's trying to get at, and I would say it is possible, but therefore it needs more evidence of kind of that, you know, someone said, you know, it doesn't really talk about the types of crimes, but if they can come back and answer that they will focus on, as you were saying, Aaron, you know, the kind of felony level and things like that. I mean, I think a lot of us, not us, I think a lot of you who work more in that system know a whole bunch of those crimes are never reported because people don't trust law enforcement. Their friend, gang member, neighbor, you know, whatever it is, beat the hell out of them or something. And unless the police are called or they end up in hospital, they don't trust the system to report that. So I think they can get at some of these, the intended harms of the bill and of what we're trying to achieve that aren't coming into contact with law enforcement or the system, but they kind of need to demonstrate a little bit more how they're going to do that. Or, as was previously suggested, maybe it's more of this, like there's more planning and funding them to do more of the planning, like we're suggesting with some of the other proposals, you know, as opposed to saying, right, you know, tomorrow we trust that you're going to be getting 20 referrals. I think there's a bit more planning that needs to happen, and therefore maybe we could suggest funding that if they come back with some revised proposals and, you know, some other stronger evidence of how that will work.
Thank you for that. Tristan, just real fast, also a note on time. Just kind of, we're a little bit over, so I know we are a tight timeline. I don't want to rush you all, but I just want to make you all aware of where we are with time. So
thank you. I'll try to be concise. So I think I probably fall mostly into Simon's camp in terms of his perspective on this application. I felt as though okay, so I guess there are a couple things. I think that when it comes to, you know, how it fits in with the rules, I think there are some continuing questions that I have around how this is going to serve as an effective alternative to prosecution and truly ensure that there is no, you know, conviction or prosecution that comes out of this. That being said, I agree with Elaine that what we all said and kind of agreed on, or, you know, expressed as an opinion, and an opinion that I hold, is that to have a self-referral system where there is no touch with the actual criminal legal system is the gold standard. And this application, or sorry, the protest letter did answer some of my questions about the feasibility of a project like this. I was also encouraged by the fact that there had been a reach out to the district attorney's office. I would also love to hear more about kind of the outcomes of that conversation. I was also encouraged by kind of a little bit more of an explanation around where these referral sources would be coming from and the community groups that Conflict Artistry is in collaboration with. I think that from my perspective, this application looks like it is on its way towards becoming an eligible program. And I think what I would want to see, and I forget if this is one of the options you gave, Bridget, but I think what I would want to see is perhaps, you know, in the supplemental funding round, that this application be represented to the committee with, you know, perhaps commitment letters from community organizations saying that they will refer cases here, and some sort of commitment letter from the district attorney's office that does give more clarity on what case types are they willing to kind of turn a blind eye to if they go through this restorative process, and how do we ensure that that prosecution is not going to happen. And I recognize that that could be a very difficult kind of agreement to work out, or kind of how do you communicate those things if these cases are not touching the system. And so, you know, I think that we can have an open mind and be creative and flexible around what that needs to look like. But from my perspective, the application isn't quite there yet, but I feel like it is on the road to getting there. And so I wouldn't want to foreclose this application from being reconsidered in the future. And by future, I mean this grant cycle.
Okay, thank you, Tristan. So oh, sorry, Bridget, go ahead.
Yeah, Rachel, if I might, just real quick, I just want to make sure we're all clear on eligibility versus preferences. So this program, the question before you today is not whether it met enough of the preferences to be eligible for funding. The question is, did it sufficiently demonstrate the ability to work with system partners? That is the actual rule we have to apply today. And I know that there are preferences about case types and referral sources, and I've heard a lot about that, which is really helpful. Those preferences, I think, would help you cut the cake up if you had too many applicants and not enough money. Right now, we are just looking at whether this program is eligible and did it meet the definition of essentially restorative justice in this grant. So to the question about what would you be able to do today, if after this you still do not feel like it adequately demonstrates the ability to, a willingness to communicate or involve system partners, then you would stick with your denial. If you think that maybe there's some reconsideration given the response letter about willingness to communicate and involve, or whatever sort of the adjective or verb you want to use for system partners to get that going, then I would suggest you reconsider. So those are just the two things. I want to make sure we're clear on eligibility, like just flat eligibility for program, and programs you'd prefer. And I see that there's some hands up, but I do want to make that clear for folks. I think Elaine's got her hand up.
Yes. So I think based on these two rules, willingness, the community-based coordination with community-based organization is very clear in the application and in the follow-up response, and the ability to work collaboratively in terms of their own expertise is really kind of clear, and the willingness. If that's the framing, the willingness also seems clear. There's a willingness for reconsideration. Oh, you know what? Shoot. I am so sorry. I just realized that I think they named Trauma Healing Project in the grant as a potential partner. We do not have any working agreement with them. They named us without us knowing. So I need to, I think it's a conflict of interest. I am so sorry.
No, Elaine, you're fine. If you're not receiving funds, you're good. Yeah.
Okay.
So I guess one thing that I'm feeling in terms of eligibility is I guess kind of not so much well, I think it ties into the interaction with a system partner, but also the existence of this as an alternative to prosecution, where they're, basically falling in line with the definition of restorative justice, where there is an assurance that there will not be conviction or incarceration. I think that that definition dovetails with the collaboration with system partners, because I think that implicit in ensuring that there is not conviction or incarceration means that there needs to be some sort of agreements or assurance from a system partner. That being said, and I'm so sorry, Bridget, I hope that I'm keeping this all in my head the correct way. I would like to reconsider this application. If we are reconsidering the application, can we ask for more from the applicant in terms of, what we were talking about before, in terms of a little bit more information about the agreement with the system partner and referral sources?
I think that would be fine. I think if we could, sort of narrow it to the, like, what's the basis for reconsideration, and then ask for some information to that point. I will say this is a new program, and we haven't had this sort of exclusive authority in a grant review committee before. So, but I mean, I think the answer is okay, because the decision you have to make today is, are we sticking with the denial? And if the answer is no, then at least we have a little more time to figure out what the other option is for reconsideration.
Okay, then, I mean, my recommendation would be reconsideration, and that there are a couple areas where we still need some more information.
I see a hand up, but I can't tell who.
Charlie,
Charlie.
Okay,
hold on.
sorry. Go ahead.
I don't feel like the ability to work collaboratively with system partners has been shown. I recognize it does say the willingness, but House Bill 2204 specifically speaks to the ability, and I don't think that's been shown. I also think that my preference would be to deny and ask for reapplication as a program development. I think that there's a lot of groundwork that needs to be done prior to services being provided. And I love the concept, and I would love to fund the development of this concept. And I would love to give them the freedom to develop this concept without the expectations of providing services yet. And so I feel like that gives them a moment to exhale and just really establish even a template that can be like disseminated, because I think everybody's talking about this being the gold standard, and I would love it to be the gold standard. And I would love to give them the opportunity to develop a program that is well thought out, well partnered, and then therefore can be well executed.
Tristan?
So I am not, I guess what I will, I'm not necessarily opposed to what Charlie is suggesting. I think there are a lot of ways that we can get to kind of the same end, which is hopefully getting this application to a position where it can be funded. There were a couple things from the original application that gave me pause that I think it could be cured through reconsideration. I think maybe a reapplication is the more appropriate route for how to address these things. But on page 11 of the original application, they talk about basically not disclosing any legal options for the harmed party, kind of indicating that they could still seek prosecution. And on page 13, they wrote, "We do not provide legal advice, and our clients will maintain all of their legally protected rights to utilize the criminal justice system as they and their legal counsel see fit." I think that from the protest letter, I am understanding that there's kind of been a shift in that approach, and that they are trying to create a mechanism where there would be, a diversion from the criminal legal system. And so, to Charlie's point, if it's reapplication, then at least, some of these things that are in the original application could be kind of addressed. That being said, I find that there's been a lot of thoughtfulness that's gone into this application, and I feel like there's been a lot of work that has been put into the application, the protest letter itself. And so I'm not trying to create more work for conflict artistry outside of getting those kind of shoring up those relationships with community-based partners and system partners.
Thank you, Tristan. Okay, just to kind of, oh, Bridget, go ahead.
I just want to make another, I know I'm always this person. I just want everyone to be clear. You can suggest that an applicant reapply. That's up to them. If they don't like how this, if their idea of what they wanted their program to be does not fit the feedback, suggesting that they reapply in a separate round is something we can suggest, but they may just say no thanks. So I just want to be clear, like, that's up to them. So there's no assurance that you would get that reapplication. That's all. I just want to make sure. And then I think Simon has his hand up.
Yeah, and sorry, and there's no assurance that we will we will have another round, because we haven't, that decision hasn't been made by whether it's the grant review committee or the commission. I don't know who makes that decision, but right now the only consideration is the current kind of RFP process that we're within, which I feel like, to get to them reapplying if they would want to, and I appreciate what you just said, Bridget, is to push it back and to say, you know, we would reconsider it if you do these things. We then reconsider it. We could deny it then if it still doesn't meet sort of those questions and concerns. But I guess it still keeps it live, and conflict artistry can choose to say, you know what, we're done with this. We protested. You still don't want to fund it. We're not going to do more work. I doubt that's the case, but it's the same as whether they would reapply or not, is do they want to take some time to submit additional evidence and thinking, and it stays live in this open grant funding round right now, because there's no assurance. I'm hoping we might, but there's no assurance today that we're going to disperse the unallocated funds. But we have this moment now that is open, and the opportunity for them to do some more work, unfunded, sadly for them, but to do some more work if they want to shore up some of these questions and bring it back.
Thank you, Simon. So just to kind of move along, we're over time, and I know that there are some other decision points that we would like to get to today. I understand that this is kind of the main thing, so I want to make sure that there's time for conversation. However, so you all can deny or move for reconsideration. Can we kind of maybe see where we're at in terms of consensus for those two options?
Yeah, this is Vanessa. I vote for reconsideration if we're voting.
Okay, thank you, Vanessa.
And this is Charlie, who has been probably the most vocal about denial, but I do agree with what Simon just shared, and so I'm open for reconsideration. And
this is Aaron. Behind that, I was probably the second most leaning in direction of denial. I'm also going to move to reconsideration, but I do want to note that I consider the existing record on collaboration with system partners insufficient. So unless it's augmented by reconsideration, I will need something else to move me towards finally wanting to approve after we reconsider. I just want to put that on the record.
Close to that, same for Elaine. I also vote to reconsider, and in particular, the protection from prosecution once a process has been gone through, and the agreement process for getting to that as part of this going forward. I think in particular to this funding stream is important.
Okay, anybody else?
This is Jimena. Jimena, and I vote to reconsider.
Thank you, Jimena. Simon has a thumbs up. Anybody? Okay, we are going to.
I'll just
wait.
sorry. Vote. I would also
Sorry.
vote to reconsider with some of the same caveats I think that Elaine and Aaron mentioned.
Thank you, Tristan.
Agreed. And this is Carrie on the phone. Sorry, y'all. It's hard to know when to chime in or not. I am very supportive of reconsideration. And just a little side note too, Sophia, since you are listening to this, I noticed on your website that you mentioned you're applying for a couple other funding sources, which is really exciting. I would love to see your program funded, and I so appreciate all of the work and passion that has already gone into this brilliant design. I do have one note, having been in the nonprofit world for more than 20 years, might be worth considering if you want to publicly state the different foundations and entities that you are pursuing funding from. Just something to think through, because sometimes that does give potential funders a little bit of pause to have it be publicly stated. So just know around that, and I'm happy to reconsider this.
Thank you, Carrie. Okay, we are going to move on. Okay, so we have 3 applications that are up for full approval. And before we get into each individual one, Bridget is going to provide a quick explanation of what we need from you all today.
I think I covered this mostly in the first go round. So essentially, you guys have exclusive authority. So any sort of review of what responses were brought in is most appropriately considered by this group. So that's why you're seeing these 3 applications returned to you. And I think that's enough.
Perfect. Okay, so restorative justice for Southern Oregon, basis for partial approval from you all. There was a little bit, it was unclear as to whether a youth's successful completion of the program would lead to dismissal of charges and not prosecution. And the committee was unclear as to whether the program includes self and or community referrals, and is there an agreement from the DA's office that those self referrals will get to the opportunity to participate in RJ programs. And then the applicant's response was the Juvenile Restorative Justice Program Victim Assistance Youth Accountability Program is utilized by Jackson County Juvenile Services to divert youth entirely from the justice system through a formal accountability agreement. And there's not a formal agreement with the DA, but the applicant did include a letter of assurance from the DA, which offers support of the RJ, as an alternative involvement in the criminal justice system. And then Bridget, quickly, if you want to cover the rule or guideline that is applicable to this.
It's essentially, does this not resort to incarceration of criminal conviction?
Tristan.
I thought that the letter from this program completely resolved the issues that I had, and I would approve full funding.
Thank you, Tristan. Anyone else?
Just to echo that, Simon.
I see a thumbs up from Aaron. Elaine, okay.
Jimena approves.
This is
too.
Vanessa. I also echo that.
Perfect. Okay, any other comments for this application? Okay, moving on. So Cow Creek, the basis for partial approval, I'm sorry. Deltra, did you have your hand up?
Yes, and I know time is of the essence, so I'm just going to be brief. I just want to thank the CJC this approval, and I want to reassure you that you will have no regrets for funding our program. We're going to go forward. This is a super opportunity, and we just need to. I'm glad to have this stamp so that we can be confident and just make this thing happen. It will take time in this rural community to forge the relationships necessary to make restorative justice work here for young adults. But there is an openness now like there's never been before. And we're very excited about it, and we appreciate the support. So thank you so much.
Awesome. Thank you, Deltra.
Yep.
So Cow Creek, the basis for partial approval was the committee was unclear as to whether a person's successful completion of peacemaking court's restorative justice program would lead to dismissal. And the committee seeks to require participants' successful completion of the program that would result in no prosecution. The applicant's response, they quoted a section of their peacemaking court code that describes the peacemaking resolutions. I'm just going to read it out loud so it's in the record. Tribal custom values finality after dispute resolution in accordance with this traditional value. If the resolution adopted as an order and judgment of the tribal court and the case was already the subject of a criminal civil proceeding, the underlying criminal or civil proceeding shall be dismissed whenever possible or appropriate. So the aim of a peacemaking court is to center the needs of the harmed party and foster accountability without resorting to criminal conviction. And several tribal members have expressed that in accordance with this traditional value, dismissal of any underlying criminal charges as a result of the successful completion of peacemaking should be respected as much as possible. And Bridget, if you want to.
Yep. So Cow Creek's response is actually very interesting, and I think it really warrants some thinking about this definition. So they're hinging on your restorative justice definition uses the term aims. If it didn't use the term aims, it would require a flat, never resorting to incarceration or criminal conviction. But because the word aims is in there, instead of it being just a black and white, it is aims means having the intention of achieving something. And their tribal code also has the intention of achieving a result outside of criminal conviction or incarceration at any point possible. We did to ask the applicant a bit about, what is whenever possible and appropriate mean? And it's up to the peacemaking court members who are members of the tribal community and the tribal court. So I think the thing that this is really bringing forward is the definition of restorative justice in this program does seem to leave a little bit of wiggle room about the exact program outcomes in every sense. That word aims is a bit of a fulcrum. So I think that's what the group has to consider here, is whether if there are a couple of instances when the tribal community does not see a person's resolution being finished without taking part in the sort of the regular process after the fact, the definition seems to maybe allow that. And I guess I think the other thing, all right, I'll stop. Okay, go ahead.
Oh, go ahead, Aaron.
I was satisfied. I felt like this was a very thoughtful response to that narrow question that helped me contextualize some slightly different ways of thinking about rules, formality, and yeah, I felt this actually went well beyond the line of being an adequate explanation and went into being an exceptional explanation. So entirely satisfied and would recommend approval.
And just to note, I'm also seeing thumbs up in that response from Ashley and Simon. So just to note that. I don't know who had their hand up next, Tristan or Charlie. Either one of you.
I would be, I'm happy to go next. I will say, I think that the word aims refers to centering the needs of the harmed party and fostering accountability within the responsible party. And I think that that's where that ends. And then a separate clause is without resorting to incarceration or conviction. That being said, I am also satisfied by the response in regards to the process of how these cases may or may not be dismissed. And it is helpful to have a little bit of additional information that decision kind of comes down to the peacemaking court and tribal court doing kind of a holistic view of how this process went. And I thought that the letter did give more context around kind of why that language is a little bit vague. I will say, I did think that another issue that we had raised with Cow Creek, and I did think I felt as though they spoke to this in their letter, or at least through the peacekeeping code, was the interconnection of the peacekeeping court and the tribal court, and whether the peacekeeping court is considered a community-based organization within the context of the definition that we provided. So I do want to approve funding for this this application. I honestly, I think it's important that we do so. I do have some concerns about how deeply intertwined the peacekeeping court is with the tribal court, because it doesn't seem to be a tribal organization that is a separate entity from the system. I would love to have some more honestly, what I would love is to have a conversation with Cow Creek about the feasibility of that, about any other considerations that we're not taking into account in terms of the differences between tribal jurisdictions and county jurisdictions. And so, I guess I raise that as a concern. It's a concern that I want to be flexible about, and I want to think creatively about. But it does still stick in my mind when reviewing this application.
I think, yeah, thanks, Tristan. So one of the things that's tough about this grant is we don't actually have a definition anywhere or like a rule or an example of what is community-based enough. And this is also going to come up in the Deschutes application. One of the things that, you know, we sort of reviewed with the applicant was that the peacemaking court is made up of tribal members who have been appointed by the tribal court because they are respected and have, you know, the integrity of the tribe. The tribal members preside over the peacemaking sessions themselves. So it does seem to be, I mean, one, it is just difficult to compare a tribal government system as a one-to-one, where we look at CBOs and external law enforcement, external states, judge systems, circuit courts, that kind of thing. But for what it's worth, you know, staff having reviewed the rules, we don't have concern as to whether this is community-based enough. And honestly, for all of these programs, really, there's no way you're going to know if it works exactly how you want it to until you implement. And over the next year, we'll get more information. And if programs are just not turning out the way and having the results that you want and really don't seem to be community-based enough, then you don't fund them in the future. But I think here we are comfortable that this is within the rules of being sufficiently community-based for what that's worth. It's not our decision, it's yours.
Well, I think that that's worth a lot. And again, I honestly, I like this application a lot. I want them to apply for more funding. You know, if that is the case, Bridget, what you're saying, then I think I am satisfied. I mean, there were some aspects where, you know, it allowed for the tribal court judge to sanction people who are in the program. That seemed to not be separate, but I am totally 100% open to what you are suggesting and to approving this for funding.
Okay, again, my screen is a little weird. I can see a hand up, but again, I can't tell who it is. I apologize. I don't know if it's a.
It's Charlie, and I don't.
Sorry.
Saying that Simon is doing a thumbs up. I don't know where to give a thumbs up, so I'm giving approval. I love the application, and it has my approval. So.
Okay, perfect. Okay, it looks like everybody has. I see Elaine has a thumbs up. So okay, we are good to move
Yeah,
on.
I don't know how to do the front thumbs up, but I vote for approval as well. I can't find the thumbs up on my thing.
Okay.
This is Jimena. I can't find that thumb. Say that I adore this application and I adore how we should not go into what is community-based enough. They're defining what is community-based for themselves. And this is the way of honoring how conflict is defined by each community. This is the example of restorative justice and what we want to see replicated elsewhere. So beautiful application. I love it.
Very well said, Jimena.
Elaine?
I think this might be true for most of the applications. I am so interested in how some of the remaining funding can be used in a centralized way to support follow-up and evaluation and tracking. You know, how we can actually be a resource, or how this funding can be used to be a resource, not to bring people into alignment with any particular, you know, dominant way of thinking about things, but really to look at the various ways people can show outcomes that match their goals and that match the goals for this funding. I mean, I think that's the minimum within the funding, but also these additional proposed outcomes that people are proposing. And so I hope we reserve some funds to really support that, so that people aren't cut short without the resources to do the kind of follow-up and evaluation, self-evaluation that we want to see.
Thank you, Elaine. That's great feedback for us. So, okay, I am going to move on to the last application. This is Deschutes County, their emerging adult program. The basis for partial approval was concern that the DA's office and the operation of the corporate victims circle operation should be instead operated by a community-based organizations partner. And The applicant's response is that EAP was a concept that was envisioned and developed by the DA's office, and shifting all of the case management and circle implementation away from that office over to CBO would essentially start them back at zero. And they would be required to basically start a pilot again. The DA's office has reached out to CBOs with specific expertise needed to develop and implemented the EAP with their input, and Deschutes County would administer the RJ grant to alleviate the burden of administration on CBOs. One thing they did note is that the CBOs are very small and don't have the capacity to handle a program such as this. They just don't have the ability to do that, which is why the DA's office decided to pilot it themselves. I also just wanted to note that there was concern about the circles, the RJ circles. The DA's office coordinates it. They do have a coordinator, but they actually rely on community partners to administer those particular circles. And so there is no communication back and forth as to what goes on in those circles. So Bridget, if you want to.
I mean, this sort of came up as like it's this question of like how community-based is enough. The grant allows public entities like a DA's office to be a contract holder or the primary grantee. So if there's any question about like, can Deschutes County get this grant? Yes, they can. It's for you to decide what community-based is enough. And, you know, the applicants must demonstrate coordination with, I don't think that's an issue as much as, is this community-based enough? And I would emphasize what Rachel said, is it does appear in their letter that the DA's office is not facilitating the actual circles themselves. And then I think Elaine's got her hand up.
Elaine, I think you're muted. We can't hear.
The reason, I mean, I wouldn't word it as community-based enough so much as, is there enough of a wall between the information and the records keeping and the tracking of what's happening with individual sort of people involved in this process. So the enoughness is not about, you know, how well they're playing together so much as, is there real protection for you know, the information sharing going back and forth and what's happening in any of the circles that are happening using an RJ process, including, you know, not being able to admit anything that happens in those processes into a prosecution process later. And so to me, that's the bigger question. In addition to, I remember how much, you know, funding was sort of supporting the DA's office. So but that's an aside. You know, people need to write the budgets they need to write with their people. But I think that's the bigger issue for me, is the separation.
Yeah, just to respond to that, Elaine, they are, like I said, there is no communication between those community partners that administer the circles and the DA's office. They just coordinate when and where those are going to happen. And so there is no communication, and they also are in the process of developing confidentiality agreements between the parties. And so there's no discussion about those.
Okay.
That was.
Can I jump in? Because I have a super hard stop at 10. So I'm going to cut. I will with a bit of gritted teeth, but I think I would like to vote to approve. I'm going to pick up on something Bridget said in reference to the Cow Creek one. Is I think over the course of the grant period, I would be looking seriously, if they were going to apply for future funds, that they have really moved to embed this more in the community. If a DA's office can hire new staff, a nonprofit can hire new staff, and they should be doing that. So I really bristled at some of that feedback. I was satisfied enough that there was a separation of how the circles were administered by non-DA office staff. So I'm satisfied with how they responded. There's a kind of a separate case management system, etc. But I would be having a hard look at how they move this further into the community. If we're supporting projects to kind of get off the ground and test some ideas, and develop that community capacity. So I like that, but that would have to be demonstrated even more strongly in the future.
Thank you, Simon. Tristan or Aaron, I'm not sure who was next.
I am speaking, so I will go next. I have a similar perspective to Simon. I think that the letter, I think the letter did a good job of explaining more about how the circle process, even though coordinated by the DA's office, is within the community. I think that there was a pretty good and thorough explanation of why the DA position for the program technician is needed. I also think there was a good explanation for why the victim's advocate was needed. I don't see a good explanation for why they need $200,000 for a half FTE for a DA's position. And so if I was, I would like to recommend funding. I would like to recommend funding for the program technician. I'm sorry if I'm not saying that title correctly the full way through. I feel like it's longer than that. I would also like to approve funding for the victim's advocate. I would deny funding for the DA position. And then I would also just like to kind of echo some of the things that Simon said. I do also want to see some genuine effort towards moving this towards the community to be more community-based, to be more embedded in the community. I think one issue that we talked about during the discussions around the rules was, you know, the sad reality that in a lot of more rural counties, the community-based organizations that could hold this program don't have the capacity or don't even exist. And I think one value in this grant program is community investment, is creating those kinds of community-based organizations so that we can have community-based restorative justice options. And so I think that for this application to be competitive in the future, and perhaps if there is a way of kind of doing kind of 6-month reviews where they can give us a status report on how they are moving towards this, I think that would be helpful. I would want to see more conversation with Community Solutions about how they could transfer the resources they are requesting from the DA's office over there and shore up their staff and increase their staff as opposed to increasing staff at the DA's office. So yeah, just like what Simon said, I would like to see them have a movement towards embedding this further into the community.
Thank you, Tristan. Aaron?
I mean, this is obviously the most systems-heavy proposal we've looked at, and I think we've all struggled with that. But Bridget, the way, to use your analogy, there's the preferences that we articulated earlier, and for the, if there was not enough cake. In the cake allocation disposition that I guess we're not in, my understanding from this slide is the two OAR-based questions before us are, I mean, a public or private entity, we did say it could be public, that the applicant could be public. So even though I think we have some reservations about that, in terms of the administrative rules, I think it's in bounds. I don't actually think we've been instructed to discredit applications that are more on the public side, as long as they demonstrate coordination with community-based organizations, which I do think is established here. Because of the possibility of program failure from the perspective of the community-based organization if the investment isn't made. So I guess I'm at a position of support, but I just want to note, it appears to me that the review committee has widespread discomfort with routing resources into systems partners. And I think that's something we should maybe consider for the next round when we talk about this and we're coming up with our weighting criterion, because I think under existing criterion, this entirely qualifies in my view and should be funded completely. I just want to note there is some discomfort about that. So I'm a yes.
Yeah, thank you, Aaron. I think there are a number of places where once we get some programs implemented, we can refine rules, refine an RFP to try to guide programs to be more of the model you're hoping for. I want to make sure that we have, before we lose people, is there anyone who is not feeling comfortable in a consensus move to fund Deschutes' program at this point, just so that so we can get this decision done today? Is there anyone who's not okay with that?
Sorry, I have a question, I guess, about my discomfort, or what I had said before about wanting to. Sorry, I keep doing this. So I guess what I'm wondering is is the decision here today like all or nothing? Like either we say, yes, we approve everything, or is it possible to say we approve part? And I also acknowledge what Erin was saying. Like, I think that when it comes to strict eligibility, that yeah, public entities can apply. But it was my understanding, or maybe this is a mistaken understanding, that it's not just on us to determine what are they eligible, but we can also make a recommendation as regards to the amount of funding that they should receive. And so, yes, I think that they're eligible. I think that these, requests are within bounds. I don't think that we should give them funding for a DA position.
Yes, Tristan, if the committee wants to not fund a particular part, you can do that. My concern is I think we lost Simon, and I don't think he had the opportunity to answer that question. And so I'm not sure.
Is it true that if we reconsider doesn't mean approval? Reconsider means reconsider. It means we have time. So Tristan, maybe we reconsider and then we don't have to fully approve when we reconsider. We can really talk more deeply about those points. Is that right? Am I correct about that?
Yes, Elaine, if the committee needs more time to talk about Deschutes, it's not the end of the world if it doesn't get done today.
But we can reconsider.
This is Vanessa. I actually have to go, so I'm so sorry. Bye, everyone.
Bye.
We've lost quorum.
Does that mean we have to discontinue conversation?
No, it just means you can't make a business decision.
Okay.
So Deschutes
Can
will
you
be
quorum via email?
no.
Yeah.
I have to go as well. I'm sorry.
So just before we lose that, we will follow up with you. Deschutes is not done. So any questions about whether it's to be reconsidered, I think we're going to talk about it again because we're not done with this process yet. So you'll get another chance to talk about Deschutes.
Thank you.
So I want to ask a question before we go, if that's okay. I understand Tristan's reservations about funding a deputy district attorney. Because I'm in a deputy district attorney's office, I think my perspective on that's a little bit different. But without getting into the merits of that, did we actually ask them squarely to justify that position? Was that ever routed to Deschutes? Because what I saw is, why is the district attorney managing the EAP rather than a CBO? Capacity questions. Why are the victims advocate and program development positions needed? Did we ask them? Because I mean, Tristan, I understand your concerns, but I don't think we ever flagged that for Deschutes. I think that was the position we didn't ask about.
That is correct, Erin. It was just the positions that you just mentioned were the only ones that they responded to. So okay. Yes, that's correct.
So then I just want to say for the record, while I think Tristan's inquiry is absolutely valid, I think it's procedurally unfair for us to use that as a basis for now reducing their ask when we didn't give them the chance to respond. So I think either we need to give them the opportunity to cure or not use that as a basis for denial or reduction.
And then I guess I would just, yeah, I mean, is it possible to ask them for clarification on that at this stage?
Sure, we can call Deschutes and ask him about that position. I don't think that's a problem.
Yes.
Okay, so at this point, we are done with the applications. We will be talking about Deschutes again and also reconsidering conflict artistry, and we'll be communicating with them. Bridget, at this point, do you want to talk about timeline or do you want to just do that?
Sure.
Video?
Yeah, real quick, the Resolve and Cow Creek applications will go to the commission next week for funding authorization. So for your purposes, those are done and we can start working on getting them implemented. Like Rachel said, you've got 2 more that still have some work to do, and we'll follow up with you to get that meeting scheduled. Thanks for everyone getting together on a tight timeline. We appreciate it very much.
Okay, that's all we have. Thank you so much. Have a great day.
Hi, everybody.